everyone. It is great to see the new folks and really great to see a lot of friends who come to these meetings regularly. So as you all know, we have a great panel, an exciting panel, and a bigger panel than usual because we have so many great speakers today. Our topic is addiction in the criminal justice system. So what I'm going to do is kind of go down the line here. We have organized our speakers in chronological order, I think, kind of, sort of. You'll see what I'm talking about as I basically identify who they are, and I'm going to tell you just a little bit about what they're each going to talk about. The way we're going to start this off is each individual is going to speak for maybe 5 to 7 minutes. Just a little introduction and some introductory information for each of you. Relating to their job and how it intersects with addiction and substance use disorder. And then we're going to open it up for questions. So, and I have a few sort of pre-prepared questions in case things are a little slow to get started, but if I know my fan folks very well, I probably won't need to use probably any of them. Maybe a couple of them. So let me make some introductions here. So to my immediate right, and by the way, I want to thank all of our panelists for giving up their Monday night to come and share information with us. It's a lot to ask on this beautiful sunny day, isn't it? So, all right, so to my immediate right is Deputy Chief Brian Miller of the Westland Police Department, and he is going to talk a little bit about addiction and the opioid epidemic, how that's affecting his work in the Westland Police Department. He's also going to speak a little bit about the program called Western Wayne Rescue Recovery, which is similar to a Hope Not Handcuffs program, sort of. That 4 police departments in our area are involved with, partnering with GrowthWorks and also St. Mary's Hospital. To his right, we have Charles Close. He is a defense attorney for the city of Wayne. He's going to talk a little bit about representing clients with substance abuse issues or substance use disorder and the challenges that these types of clients pose for him. And then to his right is Rita O'Leary, who's a prosecutor for the city of Westland, and she's going to talk about things from the other side of the fence, I guess we could say. And then to the right of Rita O'Leary is Judge Laura Mack. Judge Mack is a member of our chapter board. She's also the judge for the 29th District Court. She manages a district court docket, a regular docket, as well as a mental health docket, and so she'll talk a little bit about that. To her right, we have my dear friend, Yvonne Barnett-Green. She's the manager of specialty court services for the 3rd Judicial Circuit, the Criminal Division, and she's going to tell us a little bit about what those specialty courts are in the 3rd Circuit and what they do, what they offer for individuals who are struggling with addiction. And then to her right, we are privileged to have Robert Dunlap, who's the Chief of Jails and Court Operations for the Wayne County Sheriff's Office. He's going to tell us a little bit about the issues that Wayne County Jail encounters in dealing with inmates who are struggling with addiction, how the jail deals with those issues. And then finally, to his right, we have Matthew Costello, who's the Program Services Supervisor for the Oakland County Jail. He co-heads the mental health and program services for the inmate population there, and he's going to be telling us a little bit about a new medication-assisted treatment program that they have in the Oakland County Jail. So that is the initial introduction for everyone, and I'm going to now turn it over to Deputy Chief Brian Miller.
All right, thank you, Lauren. Yeah, so thank you for letting me be here. I'm looking forward to a chance to answer questions and speak on behalf of law enforcement here. One of the things that Lauren hit about is the opioid crisis and really how it affects what we do at the police department side of things. And I think we're going to have a common theme up here where it comes to what it's causing is resources. Is really what it boils down to. Although not every crime is committed because of narcotics use, certainly not every crime is possession of narcotics, but a vast majority of the crimes have some nexus to narcotics. So we just see a lot of resources that are involved, either directly or indirectly, with the opioid crisis. So that's one thing that we see a lot of. One thing that we've done at the Westland Police Department is we've really tried to go after delivery of narcotics narcotics causing death cases. This is something that in the past really wasn't followed up a lot on in a lot of police departments. But that's something that since the opioid crisis, we've really taken our time to follow up on those. And a lot of, I think what the problem was before, every overdose death is essentially a homicide investigation. So when you're talking about homicide investigation or death investigation, that's a lot of resources that does affect the police department and how it operates. So when we do get an overdose death or even non-fatal overdoses, again, going to the resources, that's something we pour all of our detectives into to try to follow up on and try to find out who's responsible ultimately for getting those narcotics out into the street. Real quick, the Western Wayne Recovery Program, we have partnered with GrowthWorks. Westland Police Department's always had a long working relationship with GrowthWorks. So along with Canton, Livonia, Northville Township, we started partnering in January of this year. And Michelle, who's in the audience, she'll probably be a lot better to answer a lot of specifics on the program. What we try to do, and we're a lot like Hope's Not Handcuffs as far as getting people the help they need, that moment of clarity that I have so often heard people talk about. There's a couple different ways to get into the Western Wayne Rescue Recovery Program. You could always come into one of the police departments that I mentioned, go to the front desk and say, hey, we're here, we need some help. What the police department will do from that time is they will reach out to GrowthWorks and they will have a peer recovery coach here to get set up and get that person the help they need. I know Dara hit on it, the peer recovery coaches, that's one of the things that I think helps this program is that each of the people that are gonna come out are people who are in recovery themselves. So one last thing as far as how this has affected the police department and what we do, I think it's changed a lot of the perspective of how we go about doing our business. Police department has always been kind of reactive to a certain sense. With the overdoses, it's kind of forced us to take a proactive approach to it. Our officers are now carrying Narcan. That's something that years ago, if you would have told me when I started at one point in time, you're going to be going out giving what would typically be handled by the fire department, especially in a city where our fire department gets there so quickly. If you'd have told me years ago, hey, you'll be doing this, I would have said, I don't believe it, but just the scope of the opioid crisis has really forced us to kind of change the way we do things. And so, but it's something that the community needs, and so we're glad to be able to do that.
Thank you. Thank you.
Good evening. My name is Chuck Close. I'm an attorney. I'm a resident of Plymouth, and my office is in Westland. I've been an attorney for 30 years. Prior to that, I was a police officer for 17 years. I've been asked to address some issues of representing people with addiction. I am the defense attorney, court-appointed defense attorney in the 29th District Court. I also participate in the 29th District Court Mental Health Court program as well. I was thinking about this issue of what is the difficulty in representing clients with an addiction. And I just kind of jotted down a few things, and I found out that there are really 5 problems that face the defense attorney. Number 1, I believe that people who are active drug or alcohol users are basically liars. They lie, and I hope I'm not offending anybody. They lie when they come to court to me. They lie, I'm sure, to their parents, families, and friends. They lie to the judge when they go before the judge. They tell you anything you want to hear to get out of there, to make this go away. And you know what? They're very good at it. I have been taken in so many times, and sometimes I feel foolish. But that's the difficulty. People who come to court on other non-related incidents, they just want to get through the system or do what's best for them. The second problem is defendants that I see are adults. What that means is that they are there, they can speak for themselves. As much as their family and friends love them, support them, and want to work in their best interest, I take my direction from the client. The client might be lying to me, which I assume they are, but at the end, they make their own decision. Oftentimes, clients tell me, I will advise them, there's treatment available, there's a treatment court, we can do this, we can defer it. And they say, Chuck, I'll go to jail. Because they know when they go to jail, they will be in there 30, 60, 90 days at most. And they can come back out and they can continue using. When I was a police officer, what I found out with people that go to jail is that the first time they go to jail, it's very scary. They don't know what to expect. The second time, not so bad. By the third time, it's no big deal. So it's much easier to take to jail than it is to take the treatment. The other problem that we have as defense attorneys is we are bound by the rules of confidentiality and the Michigan rules of professional conduct. Our loyalty, our obligation, and the requirement that we zealously defend our clients is paramount to an attorney. I may know that the client is wrong. I may know that they should be in treatment. But if the client tells me they're not interested, that is the end of the story. I am required to follow them even when I know deep down inside that's not the best move. Parents and families do not have any input unless the client wants them to, which is extremely rare. And then the other problem is confidentiality. What the client tells me stays with me and it goes no further. I have parents call my office or family or friends and say, I want to talk to you. And I say, I can't talk to you. I'll listen to you, but I can't talk to you. I can't comment. And I will tell you this, people who are active drug users rarely, if ever, give consent. I can only advise the clients. What is the solution? Under the current system, there are very limited solutions to get family input or parents' input. One of the solutions is you can obtain guardianship. I believe under the probate code that if a child or a loved one has an addiction, severe addiction or intoxication problem, you can obtain guardianship. The second option is perhaps before they go into heavy drug use, that you have some type of power of attorney or medical power of attorney so that you can assist them when the time comes. Other than that, it's very difficult to represent an attorney, to represent a defendant that is actively drug using. Finally, I just want to say this. I am humbled by listening to you tonight. I was fortunate to, I have 3 children, they're all adults, and all 3 of them escaped the scourge or addiction of anything. And when I hear the stories that you people tell, I'm genuinely moved. So thank you for inviting me, and thank you for allowing me to participate.
So, despite the fact that I'm a prosecutor, Chuck and I get along.
Not in court.
I am a former prosecutor at the 29th District Court with Judge Mack, and I work with Chuck close as well. So we work together week in, week out. I did also do the prosecution in Westland, and I still do the prosecution in Westland for the 18th District Court. So I work with Deputy Miller's officers there at the Westland Police Department. A little bit of personal background about myself. I've been an attorney and a prosecutor for 8 years. Since I started. At the very beginning, I've done municipal prosecution, which is district court prosecution. For those who don't know, the district court, the crimes that I deal with are all generally 93-day misdemeanors or less. So I'm not prosecuting felonies. And I think that's important to create that distinction. The county handles felony or misdemeanors higher than the 93 days with one exception. So when I get a criminal defendant in front of me or a defense attorney, the maximum amount of jail time that an individual is facing is 93 days. I have a daughter and a stepdaughter. My husband is actually a police sergeant for the city of Westland. He's been a police officer for 14 years. So from our perspective, we both deal with addiction and recovery and active users day in, day out. And if you were a fly on our wall at the dinner table, you would hear all the stories that that we encounter on a day-to-day basis. And I think we have a unique perspective. So when a criminal defendant comes to me now, I don't really have much of an opportunity to deal directly with a criminal defendant. There's new legislation in the state where a criminal defendant has the right to an attorney from the moment that they're arraigned on a crime. So it used to be that I could talk one-on-one with criminal defendants more. Now, I generally deal with the defense attorney or defense counsel. Prior to having to deal directly with the defense attorney from the beginning, I did get an opportunity to deal with criminal defendants one-on-one in the beginning. And that included meeting with them in lockup. If they got arrested and charged with a crime and could not post bond, and they were locked up. And that also included criminal defendants who had been charged with a crime, had been arraigned, and they had posted bond. So they were out on bond, and they would walk into the court to speak to me. After they're charged with a crime, I speak to the defendant or their attorney, and my job really is to make an assessment of the case. So I take a look at the file. I have access to their criminal history. I have access to the police report on this particular offense for whatever happened on this occasion. I have access to a myriad of resources that I can look at and make a determination as to how I feel about the case, what a good resolution would be of the case. Generally speaking, it's very easy to find an addict or an active drug user who has active addiction for quite a while, because the criminal history generally reveals that. It's very rare that I see someone who's been in active addiction or has a long history who does not have a long criminal history, but I have also been surprised. I've had cases where people come in and I would think that it was someone who made a one-time mistake, which I get a lot of, until their family or friends come to me. So unlike Chuck, to some degree, I do get family and friends that will come into the court, and I can tell them they get there bright and early at 8 a.m. They have the concerned, worried look on their face, and they're asking to speak to the prosecutor. And I ask them, who were you here on? And they'll say, well, so-and-so, he's in custody right now. And I feel terrible and generally have to explain to them that you're here about 3 hours early because we don't deal with in-custody prisoners until the end of the morning. But I do, when I get a minute, take the time to speak to them, mainly because I am allowed to have their input. I can take any information that they have and use it in any way that I think is appropriate in dealing with this particular case. The criminal defendant probably doesn't like it. Sometimes the defense attorneys don't like that I hear this information, but I can take the input, and I do think their input is important for a number of reasons. One, the prosecutor always can generally have an input at sentencing. So if this criminal defendant ends up accepting responsibility for their conduct, I have a voice at sentencing where I can express my concerns on behalf of the people, or people of the city of Westland, or on behalf of a victim, if it is a crime that they committed where there is a victim involved. So I do appreciate the input from the family and friends, because the more information I have, the better. So after reviewing the file and talking to whomever I think is appropriate, including witnesses or victims on the case, I make a plea offer to the defendant. I say, hey, you're charged with operating with the presence of drugs. I'm going to offer you the opportunity to plead guilty to operating while impaired. You're charged with domestic assault and battery, domestic violence. I'm gonna offer you the opportunity to plead guilty under MCL 7694A, which is the Spousal Abuse Act, which says on your first time offense, if you plead guilty and you complete probation as ordered by the court, this can stay off your record. I'm gonna reduce it to a disorderly person, but you know what, it's not gonna stay off your record because you have a bad record already, it's gonna have to go on your record. So there's a lot of things that I have to work with from a tool perspective that I'll communicate either to a defendant or their attorney, and then they'll get an opportunity to say, yep, that sounds like a good deal, or no, nope, I don't wanna be on probation. I can't do probation. I hear that so much. I can't do probation. I'd rather go to jail. Or no, I'm not pleading guilty because I don't wanna do probation, so I just want a trial. And that's fine too, because all criminal defendants are entitled to a trial in front of a jury or a judge. And I generally have no problem trying that case. And at that point, if they try the case and they lose, they're not gonna get the benefit that I offered them. They're not gonna get the chance to keep it off their record. They're not gonna get the chance to take that domestic and reduce it to a disorderly person. So once we determine the route the case is gonna take, it either goes for entry in front of Judge Mack, where they're gonna enter a plea agreement and accept responsibility to a plea deal or a reduced charge, or we're gonna set up for trial and have a case in front of a judge or a jury. A lot of times, defense counsel and myself can work out an agreement with regard to sentencing if the judge agrees. That is always my goal when we have someone in active addiction or an active user, is to be able to say, I don't want to see someone in jail if that's not where they need to be. That is not my goal, that is not justice. My goal is to look at someone and say, you need help. So let's look at your history and what you've done, and let's see if there's a way that we can work this out and get you the help that you need. And Chuck and I think, in that regards, as long as his client is willing to do that, we work well together and have worked well together in getting them the resources they need. The difficulty arises for, obviously, the defendant who doesn't want the help or doesn't think they need it. And those are often the cases where we just have to try them, because if they're found guilty, the judge can order the help. And the defendant at that point doesn't have to agree with. So that's a little bit about the process. I try to be very non-judgmental in what I do. I remember the first time I encountered an addict in custody, I immediately sat down with them and I looked at them and I said, what's your drug of choice? Because I immediately saw their criminal history and their appearance, and I knew that that was their problem. Ever since then, I've tried to take the approach of eliminating the stigma associated with addiction, because anyone could fall into that pattern or to face the same situation that any one of these criminal defendants are in. And I think it's very important from a prosecutorial standpoint that I not judge them, and that I try to be understanding of their situation and try to take each scenario based on the facts that are coming to me, and to not treat every criminal defendant as if it's a one-size-fits-all approach.
Hello, everyone. I guess it's my turn. I am Judge Laura Mack. I've been the judge in the 29th District Court for 15 years now, going on 16. I preside over a misdemeanor docket, like Brita was talking about. These are the less serious crimes, the crimes that are punishable by up to a year in jail, for the most part. Most of the crimes that happen in the city of Wayne are 90-day or 93-day misdemeanors. The number one crime, what do you think the number one crime in the city of Wayne is? No? There you go. Driving while license suspended. That's not a crime that you would associate with drug use, but surprisingly, it can be a good indication. People that fall into addiction often commit driving offenses. They drive on a suspended license, they don't pay a ticket, things like that. So that's the number one crime. Unfortunately, you can't tell that that person is addicted when they come in front of you. It's only if it's a crime like retail fraud, possession of paraphernalia, possession of drugs, those kinds of things that are the tip-off. I just want to tell you a quick story. When I was first a new judge, and I didn't come from a criminal justice background, I was a tax lawyer before I became a judge. So I had no dealings with the criminal justice system, which in a way was good. I was unbiased. I was not for the prosecution or for the defense. But one of the very early defendants that I dealt with, it was a retail fraud charge. He was charged with stealing formula from the CVS. And he told me that he was stealing the formula for his baby. So I believed him. I thought he was telling the truth, and I thought, that poor man. And then I learned that that's a common thing, that people steal formula and then they sell it to another market and get cash for it so they can go buy drugs. So this was a very common crime that people commit. So when I was told that by the police sergeant who conducted the arraignment, I felt very silly. But as Chuck said, people that are in active addiction do not tell the truth. And it can be very difficult to figure out what the truth really is. So I also am the presiding judge over a treatment court that we started in 2013. And it is a mental health court, but because mental illness and substance use disorder go hand in hand in the criminal justice system, we deal with both, really. Most of the people in our program have co-occurring disorders, which means that they suffer from both the mental illness and a substance use disorder. It's interesting to me that people will admit to having a drug problem rather than admit that they have a mental illness, which is really sad. That there's less stigma, believe it or not, for that than there is for admitting that they have a mental illness. But often they do go hand in hand. The difference between my mental health court and a regular docket is that I'm just going to briefly walk you through what I normally do, how I see defendants. I have nothing to do with the issuing of charges. That's all the police and the prosecutor. They are the ones that decide who gets charged with a crime and what crime they are charged with. The next step in the process is they come before a judge to be arraigned. And that is the process where I tell them the charge against them and the maximum penalty. Now that we have representation for virtually every criminal defendant, I don't have to tell them the charge and the penalty. That is what Chuck does now as the court-appointed criminal defense attorney. So then they enter a plea, either guilty or not guilty. If they plead not guilty, I set a court date. The next court date is the pretrial. So the critical decision for me at that point is setting a bond. So if I have somebody in front of me, we actually had a case today. He was charged with paraphernalia, drug paraphernalia. He had a crack pipe, and he had admitted to the officer that he had used the day before. He also said he was homeless. And so the question becomes, do I hold this person in jail if they're in custody, or do I let them free, give them a personal bond, and give them a date to appear in court? So this is a very awesome and difficult decision, as you might imagine. Usually, I have no family members there, no other information other than the criminal history and the driving record. You can learn a lot from that, but obviously not everything. So what the purpose of a bond, there are two purposes. Number one is to assure the person's appearance in court. The second purpose is to protect society. So it's interesting because some judges interpret that to mean society other than the defendant. I interpret that to mean society as a whole, including the defendant. So unfortunately, I sometimes think that people are better off in jail awaiting their court date than they are if I let them go. Now, if the family is present, and if they are there to give me information at arraignment, that makes a huge difference. I have had families that come to me and say, we're taking him to rehab. We have it all set up. We have an appointment. I can vouch for this person. This person will get into rehab. You don't need to keep him in jail. I am more likely to give that person a personal bond if the family is there and is willing to take charge of the person and help them get into treatment. I've done it many times. There are some judges that don't like to talk to the family because they feel it's a violation of the ethical rules. that you have to talk to both sides. You can't just talk to, I can't accept statements from the family because the prosecutor and the defense attorney have to both be there. I do it anyway. I have not had a complaint filed against me because of that, because I want information. I want to know what is the history. Is the family there willing to help? Because there's a lot of family members that, you know, the bridges have been burned. The people, the defendants have burned their bridges behind them. They've abused their families, their friends, to the point where they're not willing to help anymore. And so then I'm left to just make a decision based on the facts that are in front of me and the recommendation of the police department and Chuck's vigorous pleas to not put the person in jail. Chuck does his job very, very well. He is an excellent defense attorney. Having been a sheriff himself, he knows the weaknesses in the system and can exploit them. So he is a wonderful advocate for the defendants. I know our old police chief just hated Chuck. He's gone. He's gone. I think you're fine with our current police chief, but it is very interesting, the whole dynamic. I have my role to play, the prosecutor has her role, the defense attorney has his role, and we all play our parts, and we don't intersect with each other all that much. But I don't have the answers as far as addiction goes. It's a huge problem. I've started noticing the opioid epidemic about 8 or 9 years ago, and I happened to, it was before I think FAN was formed, so it had to be longer than that. But I actually talked to Judge Davis, and she told me about the pills leading to the heroin, and that was the first time I had heard that. And I became a big fan of Linda Davis after that, and I heard about her daughter, and the passion that she has for this is just incredible. But I started noticing more and more people being addicted to opioids. I started asking defendants, which in the beginning I was really uncomfortable asking people if they had a problem with alcohol or drugs. I don't have that problem anymore because I look at it the way that I'm saving their life. I'm potentially saving their life by finding out. And if somebody is caught with a syringe and they're charged with paraphernalia, I assume that they're using heroin. They do sometimes lie, but sometimes they've been away from the drug probably a few days. By the time they see me, they've been in custody, and sometimes about 50% of the time, I think they do tell me the truth. A lot of times they'll say, I had a problem, but it's gone now, you know, that kind of thing. But then I'll say, well, when was the last time you used? And they'll say 4 days ago, 5 days ago. So I know that they're still in active addiction, even if they think they're not. So I know that that's a really dangerous time, and I know that if I let them go, and they go and use, they could easily overdose because of the tolerance dropping. So I am fearful of not letting people go because I'm afraid they're going to go out and use. I'm afraid they're going to detox in the jail. So those are my concerns. Sometimes when I do not grant a personal bond and I do what's called a minimus, a commitment to jail, I will put on there active addiction, may have to detox. I put it on the minimus. So that the jail is aware, and Chief Dunlap will talk about that in a few moments, so that the jail is aware that there might be a problem with detox, and to watch for that, because I am concerned about their safety, but I want to save their life as well. So if I had somewhere to put the people, if I had a rehab facility that they couldn't walk away from, and they could detox safely, and those people would make sure they got to court, I would give everybody a personal bond and allow them to go to that place or to order them to that place. The problem is, I can't do that. I don't have the power. I can order somebody into treatment, but then they have to call Pioneer, and if they say no, they're not going to pay for it, they won't take them. So, although I can order people into treatment, I really can't. It's up to insurance, and it's up to Medicaid and all of those rules. So it can be very frustrating from a judge's perspective. The other times I see people are at plea, when they take a plea, which is 99.9% of the time, they take a plea instead of going to trial. There are very few trials. So they take a plea, usually it's to a lesser offense. And then I have to just, then it's sentencing. So I have to address bond at the plea, and then I have to address sentencing conditions at the sentencing. So I really interact with the people 3 times before the sentence. And at those times, I set bonds or I change bonds conditions. If I do let people go on a personal bond, I'll say, okay, you have to drug test. Let's say it's a drunk driving, second offense, and the person's working, but I'm concerned. So I'll either order a scram tether, an alcohol, a device that detects alcohol coming out of the skin. I'll order them to test, but then it's up to them whether they do. If they don't, they violate the bond and they can be locked up. However, it's still a risk, and I still wonder, when I give people like that a personal bond, whether they're going to go out, get drunk, and kill somebody, and it's going to be on my conscience. But I do the best I can with the information that I have. These are tough decisions, and if you all know the answers to any of these things, I'd be more than happy to hear about them. I'll pass it on.
Good evening, everyone. My name is Yvonne Barnett Green, and I'm the manager of specialty court services for the 3rd Circuit Court Criminal Division. And I oversee our 3 treatment court programs, being adult drug treatment court, mental health treatment court, and our veterans treatment court. We also have a probation compliance program, which is our Swift and Sure sanctions probation program, which traditionally doesn't take a treatment spin. However, we find a lot of those participants do have substance abuse issues, so we do refer them to applicable treatment. All of our programs have specialized target areas, target populations. So we target those populations through our pretrial services department, our Wayne County Prosecutor's Office, and working with our defense attorneys, and also in combination with partnership with our Wayne County jail staff, where they help us identify a lot of our mental health treatment court participants when they're screened in the jail. We get those referrals from them. And all of our programs have centralized goals where we're trying to reduce substance abuse and mental health issues in the jurisdiction. Also, reduce crime-related issues in the jurisdiction based upon someone's substance abuse or mental health status. We're also trying to alleviate the congestion of jails. So instead of detaining someone, we want to refer them to treatment if that's what they truly need, because we all kind of understand jailing someone isn't going to fix the problem. So we want to find alternative programming for these eligible defendants. We screen participants for the programs. All of our treatment programs are voluntary. So, as the judge was speaking, we have a plea agreement that the defense attorney can work with the Wayne County Prosecutor's Office. You know, some participants who really want to get the help will say, okay, I'll do 2 years intensive probation because I truly want the help. We work with community partners where we're able to provide treatment at no cost to the participants, so that's major for a lot of our population that's criminal at the circuit court level that possibly the district courts don't have access to. So we take advantage of that partnership we have in the community with our partners who can provide treatment for our participants. We try to do as much community service as we can to get the word out, because a lot of times when people come to the court, they don't know about our program. So we try to educate our defense counsel. We stay very active in our prosecutor's office. We have specialized docket attorneys who know about our programs, and they will actually come to us and say, hey, we have someone, you know, would they be a good fit? All of our programs, except for Swift and Sure, we can't take violent offenders. You'll be amazed sometimes the cases the prosecutors will bring to us, and we're like, it's kind of borderline, but they're pushing, they're advocating. So I don't think a lot of people in the community know that there are so many people who are on the front line who are really trying to help, from the prosecutor's office down. And so I'm happy to be a part of that effort because I see the struggle. And I'm one of those people who innately believe in the good in all people. So, you know, I have a beating heart. So when I tell these participants, and I don't really get into the day-to-day, our coordinator and case managers do that, but certainly I take an interest in our participants and their growth, and we take a holistic approach. So it's not just giving them treatment. We understand that it's great for you to have the treatment, but okay, once you have the treatment, do you have stable housing? Are you employed? Do you have clothing to go on a job interview? So we take a holistic approach when we're dealing with our participants. It's not just this one section where we're like, okay, just treatment. Because we understand that if you don't have stable housing, you're gonna be more likely to go back to your old habits, and go back to your old neighborhoods where you're more comfortable and not feel so comfortable to move out of your comfort zone. So I want to thank you all for having me here. I've known Lauren for some years now, and I met her through Judge Davis when I was at a conference several years ago, and that's how we connected. So we're always here, the court is always here to help where we can and be of service to the community in which we serve. So thank you for having me here tonight.
So I am convinced that nothing can ever separate us from the love of God. Not death, not life, not angels or demons. Neither our fears for today or our worries about tomorrow. Not even the powers of hell can separate us from God's love. So why did I start out like that? My name is Robert Dunlap. I'm the chief of the Wayne County Sheriff's Office. Been in law enforcement for 33 years now, and I've learned a lot over the course of that 33 years. And I started out my career with the Detroit Police Department, where I retired as the assistant chief, and put a lot of people in jail. People for a lot of different reasons. And one of the things that I found in my first career was about 76%, 80% of the people that we arrested had some connection to drugs. Now, as the chief of the Wayne County Sheriff's Office, I kind of see that a little different, because now I'm the person that once they're put in jail is responsible for their custody and care while they're there. But more importantly, what happened when they leave? What do we have available? And so you heard Ms. Green talk about, a holistic approach. I firmly believe that, there's 5 dimensions to wellness for all individuals. There is the physical health, the mental health, the social health, the psychological health, and the spiritual health. And in order for the system to really work, the criminal justice system, it has to somehow touch all of those dimensions. In the Wayne County jails today, we have an average daily population of about 2,300 people. We have about 700 people that's out on tether, electronic monitoring, and another 1,600, 1,700 in custody. Of that 1,700 in custody, we have an average of about 800 people that's on medication, almost half. We have half of them on medication for mental health, and the other half on medication for various physical ailments. We believe also, based on our data, that all of them represent all of the people that are on medication, 76% of that is related to an addiction or some type of connection to drugs. I don't believe that there's any family in America that has not been impacted by this. Not one. Maybe not, our immediate brothers and sisters, sons and daughters, but somewhere there's someone. I'm from a big family, and I can tell you certainly throughout my family, there are people who have suffered from these elements. In the Wayne County Sheriff's Office, under the leadership of Eddie Napoleon, the sheriff, one of the things that the sheriff has done about 5 years ago is he's identified funds through what we call our commissary fund. It's funds that are generated from the sale SNAP goods to inmates. And we were able to set aside $1 million to partner with several residential treatment providers. And how we use that funding is when we book people into the jail, there's a screening that takes place upon intake. And a lot of those individuals might be in jail on a low bond. They can't even make a $300 or $400 bond because they burn all their bridges with their family members because of the addiction. Okay? And so what we've done is we've identified treatment providers to connect these individuals to. And so we have in Wayne County what's called administrative jail release, where based on certain factors, we have the authority of the court to early release an individual from jail to treatment. And in addition to that, we just recently kicked off a project with our Chief Criminal Court Judge, Judge Timothy Kinney, and Chief Probate Court Judge, Freddie Burton, which is a misdemeanor project where we're trying to find alternatives to incarceration for people that are suffering from mental illness or substance abuse, opposed to being incarcerated. So we just kicked this off. We have a pilot of, we want to look at the first 100 people where we move them from jail to treatment, connect them with a peer coach and counselor, and follow them for 6 months and see if we can make an impact on recidivism. But more importantly, in addition to connecting them to residential treatment, we've also partnered with the Michigan Department of Health and Human Services Rehabilitative Services Program, where they're coming in doing in-reach in our jail to connect those inmates, not only with treatment, but with jobs. That's a program that we just recently kicked off. I really don't have the data to tell you the success of it. I believe we have about 10 people enrolled in that program right now. But in addition, we, because of the opioid crisis in all of America, not just Southeast Michigan and Wayne County, we now train every employee on how to administer Narcan. And so through a partnership with the Detroit Wayne Mental Health Authority, every member of our agency who wants to avail themselves to it has been trained. They have their own kids. And unfortunately, we have had a couple of instances last summer where we actually had to use it in the jail. We had a couple of female inmates that smuggled drugs into the jail and pass it around. And thanks be to the good Lord, we were able to avoid some tragedies because of that training. So when Judge Mack said to me, Robert, I want you to be on the panel, I was like, well, you know, what do I talk about? I can tell you, I'm really humbled by all of you that's in this room, and people like Judge Mack. It takes a lot for a person to take 3 hours on a Monday to come sit in a room like this to hear about what can we possibly do to help address something that affects us all. And I think probably a lot of you, because it's someone that's very close to you and that you love dearly, and even to those of you that say, hey, I'm in recovery, I'll end like this. One of the things that I say to a lot of people when I talk to groups like this is I'm inspired by the words of a great prime minister who was only like 5 feet 6 inches tall. And one of his most famous speeches, was simply these words: never, never, ever give up. Never give in. Never, 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 never give up. Never give in. And he said that to, and I understand that the speech was probably a little longer, but that's what people remember the most, right? And I had the occasion to share that with a young lady who, her mother had called to jail. It just so happened this Saturday, I went in as the chief, and I'm working the desk because we're busy backed up with bonds, And so I told the officers, okay, you know, I don't know the entire process, but I'm gonna answer the phones and schedule visits. And this one mother said to me, I just wanna make sure that I'm on my daughter's visit list, so I can come down and put money on her account. And I pulled up her picture, and I looked and I'm like, okay. Ma'am, your daughter's been here quite a bit. She says, yes, she has. I said, well, hopefully you're not offended by what I'm about to ask you. I said, but I can see obviously your daughter has some challenges. She said, yes, sir, Chief, she does. You know, she has an addiction. She says, and nobody else wants to have anything to do with her. You know, she says, but I said, well, thank God that you haven't given up. I want to make sure that you're on your daughter's list. I said, but I need you to do me this favor. Before your daughter bond, it was only a $200 bond. You tell them, don't let your daughter out until you talk to me. And I gave all of my staff that work. Well, luckily I was able to get back to the jail the next morning. And I grabbed a team of people and we went up to visit this young lady. Come to find out she was a 17-year employee of the United States Postal Service. And got involved with the wrong crowd. And the only reason that she wasn't out because the person that has been a negative influence wasn't able to make contact with her. And as I heard someone say, when I told her I was looking at getting her out of the jail, right away, so, oh, yep, I'm gonna do everything right and everything. I told her, I said, even if you don't do everything right, if you slip and fall, I'm gonna come back and we're gonna help you again. And so I say to all of the families, all of you out there, you gotta continue to do what you're doing. Because one day, by the grace of the good Lord, they'll hit that wall and they'll say, yep, this is it. But we can never give up. And I'm proud to tell you that that young lady has been in treatment for 3 weeks. And I didn't know her from the next person, but I just happened to be on that desk. And that's the type of commitment that you have in the Wayne County Sheriff's Office from the sheriff himself, Benny Napoleon, and also some person that I've come to love, Judge Mack and her husband. I mean, everywhere I go, and it's about these issues, she's all over it. Thank you.
Thank you.
And I'm gonna follow that. Thank you. Maybe Lauren's genius is rearing its head. She went from the arrest standpoint down to the jailers and everything in between, right? So quite a nice job doing that. So I'm the last stop, so to speak. My name is Matt Costello. I'm representing the Oakland County Sheriff's Office, and I really appreciate the opportunity to speak with you guys today. I kind of have broken my short part down into a couple different sections. One is just a broad stroke overview, and then a more shorter version, but a discussion about the in-jail medication-assisted treatment program within the Oakland County Jail. I represent the Program Services Unit in the Oakland County Jail. The Oakland County Jail has a population of about 1,450 adults, males and females, with charges ranging from misdemeanors to very serious felons. People can be in the jail for anywhere from an hour to several years fighting their case, depending on their situations. The Program Services Unit is comprised of 12 caseworkers who meet with the individuals in both individual and group counseling sessions to determine what needs that they have and try to meet those needs while in the jail. About 30% of the jail population at any given time, similar to Wayne County, I think, in that regard, are open with a jail-based psychiatrist. That's 415 people open with a psychiatrist. You're not going to find private or state-run hospitals with populations that run that high. Obviously, within that same population, we have a high degree of co-occurring people, people who are battling both their addiction issues as well as their mental health concerns. About 2.5 years ago, we were approached by Oakland Community Health Network. They change names all the time. I just want to say CMH all the time. But it's now Oakland County Community Health Network Substance Use Disorder People. They had this idea, said, what about starting an in-jail MAP program? Well, they had to explain it to me a little bit. I'm a social worker by trade, so it should have been more familiar to me than it was, so I have to plead some unfortunate ignorance in this part. And they started talking about, well, you know what, you're going to introduce methadone, Suboxone, Vivitrol into the jail. And I'm inside, I'm biting my cheek. I'm saying, I'm supposed to go back to the command staff and say, listen, we got this great idea. We're going to introduce these, I'm gonna call them now medications. My ignorance at the time was, I was calling them drugs, right? So we had these conversations. They were pretty lively conversations, and how would we do it and what would it look like? The sheriff, in his multi-pronged kind of approach to trying to deal with the opiate addiction, gave the go-ahead. So that started a process by which OCHN, is our acronyms galore, was awarded a grant to start the in-jail MAT program, Medication Assisted Treatment Program. About a year and a half ago, the program started. OCHN partnered with Sacred Heart Rehabilitation Services. They import a doctor who comes into the jail once a week to meet with and prescribe medications to any of the participants that have been screened eligible. Sacred Heart also has a therapist who comes in and runs both MAT-related individual and group counseling for the MAT-involved participants. When we think of MAT as it relates to the jail, we also have to think a separate group for males and females, because the groups don't mix. The Sacred Heart also imports a peer support specialist who works with each of the participants for the purposes of connecting them with licensed providers in the community for post-release services. So it's pretty comprehensive that way. WellPath, which is our medical care provider inside the jail, a private company, is in charge of administering and monitoring the participants as they take their medications. The program services unit that I'm responsible for is responsible for finding the participants. In about the year and 4 months since the program has started, over 2,000 individuals have been screened by our population monitor as having some sort of addiction issue. I wrote it down today, I hope to remember. 1,500 of those 2,000 were identified as primarily an opiate-involved, if not polysubstance user. All right? So again, the numbers that we all know, the numbers you all live, and the numbers we've talked about are real, right? So the screener goes through that population, determines whether or not they meet the criteria. This is a pilot program, so some of the things I'm going to say might not sound very great to you, but we deal with what we got. OCHN's grant application required it to be open only to Oakland County residents. So the participants have to reside in Oakland County. They have to be 18 years of age or older with no guardianship. They can't have any out-county warrants, that meaning that any other county that wants them for other unresolved legal issues cannot participate. The thinking behind that is in theory, they could be snatched up out of the Oakland County jail, transported to Acme jail, that's a bad name, jail, and stop services, right? They could be taking Suboxone and all of a sudden be gone for 2 weeks and go through the withdrawals all over again. They cannot be pregnant. They have to meet the security concerns of the jail. So they have to be low, medium to minimum security level of the jail. They have to be, what else? I haven't written it down, I'm just reading it. Obviously a history of opiate use, right? They have to comply with all the rules of the participation as set forth by Sacred Heart Rehabilitation Services. So you can't skip groups, you can't skip the individual sessions, you can't skip medications, you can't not go with a peer support specialist. Any of those violations can remove you from the group. You have to meet the rules of the housing area that you're assigned to. Since these are low security, low minimum security individuals, there are different rules for that part of the jail than there are in other parts of the jail. So you have to be compliant with those particular rules and regulations. And that, in a nutshell, we've had, like I said, 1,500 open people were screened. 1,000 of those were found to be charge ineligible. All right? So again, their charges were of significant enough nature that didn't allow them to achieve that security level. 580 were out-county resident, meaning they may have met every other criteria except their county of residence. 146 had out-county warrants. This is a problem we hope we're going to try and mutually solve, because one of the things we're starting to get some feedback on is other county jails are becoming more interested in exploring setting up a MAT program inside their facility. So if we were to partner with Wayne County Jail as an example, sorry, Robert. So that would resolve that writ issue. So if they were in Oakland County Jail, had to go down to Wayne County Jail for issues that they had there, they could continue the treatment unabated. Right, they got that, yep. Yep, same provider. So again, we're seeing some progress towards resolving that kind of issue, because we think that's an easily solvable kind of issue. 152 people so far in the year and 4 months have successfully completed the in-jail portion of the group, or the program. They've been released into the community. There is no time limit on the amount of time you can be in the program. What we're most concerned about is getting you as early as we can, right? As early in the incarceration, so within 2 hours of somebody coming into the jail, a WellPath nurse is doing an assessment on every book that comes in that reports anything. It could be for medical issues, it could be for psychiatric issues, it could be for addiction issues. That starts the clock, because everything Sacred Heart is looking at is this immediacy of services, right? So that part, but once they're into the program, they can be in it for an undetermined amount of time until the court adjudicates their case, they reach the out date, and or they post their bond and are released. Unscheduled releases are not our favorites, but we still, at the onset when we first screen them, which is within the first 24 hours of their arrival, we are already giving them discharge information should they be unexpectedly released. So we're trying to cover for that particular variable. 22 people are currently active into the program. It happens just to be 11 males, 11 females. The prescribing rights are solely at the discretion of the doctor. The Sacred Heart doctor has full rights and responsibilities to determine the course of treatment for every individual. The Sheriff's Office, OCHN, has no say-so in the matter whatsoever. So it's a relationship between the participant and the prescribing doctor. The most interesting number of the ones that we've talked about is 71 people were found to be eligible and still declined the program. So that's a population that, from a program services standpoint, we have to find a way to mobilize and create an avenue by which we can impact with them, because we are also limited, one of the other criteria, we're limited to no more than 25 participants at any given time. There's a variety of reasons for that. One is grant, the other is security in terms of transporting people into the group rooms. Our dosing is all done in the jail clinic. Other dosing for other medications are handed in the housing areas for each individual. The MAC participants are dosed in the jail clinic specifically because we worry about any diversion, right? The methadone is obviously liquid. The Suboxone is dissolvable tabs. We've gotten it down to the point where we are giving Gatorade with the dissolvable tabs because it tends, what I've been told, I don't know this scientifically, we were told that dissolves the Suboxone tab more quickly than just water, right? The Vivitrol is not something we worry about again because it's just an injection, but it's still administered in the jail clinic. And that's basically what I had. I'd hope to spend a lot of time just trying to field questions because that's more my ballpark than presenting.
All right,
And can I just add, I brought some program brochures that I left on one of the tables as you enter. So if you want to learn more information about each of the programs that I've talked about, there's some brochures back there. And if you have any family, friends who are going through the judicial system at the circuit level, certainly give them that resource.
okay, we have about, do I need to bend over for this? I don't think I do. We have about 20 minutes, maybe a little less than that, for questions. And I had a few that I was going to ask, but since we only have about 20 minutes, I think I'm going to just open it up to all of you because I'm guessing that you may have some questions for our many panel members here. Let's start with Bob.
Just in my daughter's journey in addiction, I think she touched the officer down numerous times with something. But I just want to thank you for everything you personally, our guys, are all doing for this issue. I mean, I think when I first went to the first fan meeting in April of 17, it was like, okay, this entity is working over here, this entity is working over here, and this entity is working over here. And it's, into my observation, in 2 years, it seems like, with all you on a panel, that there's more communication, more sort of targeting the same goal here. So I applaud you for that, and I just thank you for doing what you're doing.
You say that you're doing a program with Suboxone. Now, when somebody gets arrested and that is already on the medication, like Suboxone, methadone, do do you allow them to stay on it, or do they have to go through your program to get on it? Because I used to have patients that they were not allowed to take it when they went to jail. So they would go through their withdrawal, and then when they got out, they didn't come back to us. They went back to the street.
If they were screened and determined eligible, they met the criteria that we talked about earlier, and they meet with the prescribing doctor and they were taking Suboxone, that medication would be continued as determined by the Sacred Heart doctor.
So it wouldn't matter if they're already prescribed. If that Sacred Heart doctor said, no, he's not eligible, or she's not eligible, even though they're going to a doctor that's prescribing, then they wouldn't get it.
If they are gotten to the point where they're actually meeting with the Sacred Heart doctor, they're going to get medication. The bigger population that we're talking about that may directly answer your question, if Jane Smith from Washtenaw County was taking Suboxone prior to coming to the jail, she would not receive Suboxone inside the jail currently. In our pilot format, that, because of county residency, would make her ineligible to participate. So she would then be medically managed on the detox portion of it. There's not, so the WellPAT people would then manage the detox situations for that particular individual. Does that answer your question?
And just to, you may be aware of this, and some of you may be as well. I mean, there have been lawsuits that have been filed over, and not in Michigan, but I kept one in Massachusetts, and I can't recall what the other one was. One for a person to stay on methadone, another one to stay, I believe, on buprenorphine, and I think both of those ultimately were found in favor of the patient or the inmate, that when they went in to serve their time, they would have to continue it, just as you would if a person was a diabetic who was getting insulin. So it's coming. I mean, I can't, that's a change that's coming. I'm pretty confident, because it's sort of a wave.
Yeah.
Yeah. Other questions? Oh, yes.
This is more a comment than a question. I wanted to thank Ms. Dunlop and Mr. Dunlop and Ms. Green for the holistic approach that you're doing in Wayne County now, because my family member, when she was on probation, which her charges were in Macomb, she kept violating because she was living in Wayne County, had no transportation, no license, so she kept missing her appointments. And finally, when she got transferred to Wayne County, she got a sympathetic probation officer that came to see her at her job, and she finally got off after 4 years. So bless your heart, and thank you so much for being so open and holistic. It made a difference.
And to that, a lot of times what can happen too is, say if a defendant has committed a crime in another jurisdiction, say we have someone who committed a crime in Ingham County but lives in Wayne County. There's a way to go through the judicial system where you can transfer the supervision to the county in which they live, so that they can still be eligible for the programs that we offer. They just have to be screened to make sure that they're eligible. So it's not always like, a hardship, because going from Wayne County to Ingham County to report for probation, do your drug screening and all of that can be very taxing for someone who, one, doesn't have transportation. Two, the support of someone who can transport them there. And if they're working, trying to maintain their job and coordinate getting to probation. So we do also have those type of partnership with other jurisdictions where we can manage people who have cases in other jurisdictions. So that's a plus also.
And I should just offer that we do that too in the Western Wayne County Regional Behavioral Treatment Court. We actually serve 11 district courts in the Wayne County area. But anybody in Wayne County who is a misdemeanor, has a misdemeanor offense, and has a serious mental illness is eligible to participate in our program. So we do get many transfers from other courts.
Other questions? Yeah.
Yes, this is for Ms. Green. How do you get to the circuit court level? What crimes do you have to commit to get to that level?
It's a felony. So, most of our participants, not all, because we do have some participants who may even with their felony, may only be facing, say, 6 months probation. However, our programs are at least a minimum of 18 to say 24 months intensive supervision. So we have judicial supervision and case management. So we're looking for people who truly want help because our programs are voluntary. For our veterans court, there's more of a carrot at the end if you successfully complete. Under the statute for veterans court, they can have their felony either dismissed or discharged upon successful completion. Generally with drug court and mental health court, they don't have that carrot. It's not that it can't be offered, but generally, the statutes don't speak to that. So unless the prosecutor is willing to make that type of offer, it's genuinely because that person truly wants help. So they'll go through the 24 months of intensive probation, and go through all the, I say hoops, but it's really not hoops, that they have to get sober. So we offer a lot for everyone. And generally with felonies, you're looking at jail time of over a year and 1 day, correct? So if you're going to prison, you're looking at prison time, not just Wayne County Jail. So, like the judge mentioned, some people aren't afraid of jail. So they'll say, I'll just do the jail time, they're going to be done with probation in 6 months. And then you have the other side, which really wants to help.
I have a question that I want to direct to Judge Mack and Rita and Chuck. We've had, at prior forums, there have been many times that family members have basically raised the question, and I've been in this situation myself, where your loved one ends up with criminal consequences, and as a family member, you know things, and you know what the history, and you know or believe you have a pretty good idea of that they need treatment or this or that. I think I already know the answer from Chuck that you don't necessarily go to the defense attorney. I think maybe you go to, I mean, the question is, who should the family member go to? Who is the best person? To the judge, to the prosecutor, to the defense attorney? When you want to share information that you think is important to help get your loved one the help that they need.
Let me take a stab at that. It's funny because I was talking to a colleague of mine, Mike McNamara, who's also a prosecutor, been doing it much longer than I have. And that's the exact topic kind of we were talking about. And Judge Mack can agree or disagree, and Chuck can as well. But I think it depends on the stage they're in within the criminal process. So obviously Chuck said he could listen, and that's about it. He can't really disclose any sort of, confidences or anything like that, or comment on what they're telling him.
Unless there's consent.
Without consent, right. But pre-plea, so prior to them entering a plea, so from the time they've been charged, been arraigned, and before they enter a plea, I think the prosecutor's the best person, and maybe the judge at arraignment, if the judge is willing to listen. However, the prosecutor always has a seat at the table, generally prior to that point, right? So when they're being arraigned, prosecution can have a say on bond. At the pretrial conference, the prosecutor can comment on bond or ask for modifications of bond based on information that they know. And then in entering a plea, the prosecutor has the ability to negotiate a plea agreement, like I think Ms. Green has talked about, where we say, hey, if you do 1 year intensive probation, we're willing to recommend that this be removed from your record at the end of that period, if you can do that. And those are the tools that we have in trying to come to a plea agreement that is in both the people's best interest, but also, helps the defendant. So prior to entry of the plea, up until the time that they plead guilty, I think the prosecutor would probably be the best person. And then once they've been sentenced, I don't necessarily think it's the judge at that point, it's more their probation agent, their probation officer. Because at that point, once the judge has instituted a series of tests or conditions that they have to comply with, or for purposes of sentencing, they're going to be interviewed by their probation officer. Their probation officer is going to make a recommendation to the court as to concerns that they have for sentencing or supervision. And then while they're on probation, the probation officer is in charge of ensuring they don't violate. So the probation officer, if they're made aware of potential conduct that would constitute a violation, can investigate it and then make a recommendation to the judge if they think additional treatment is needed, or if they think their limit is violated.
listen to families that come to me after sentencing. Sometimes they'll call the court rather than the probation officer. They'll write me letters, which I review. They could say they're not complying with their probation, they're still using, and I will take that into account. If your question has to do with the decision to charge or not, that's a whole different thing. The court obviously has nothing to say about that. That would be the prosecutor and the officer. And there are in some jurisdictions diversion programs. And I don't know how far along we are, in Wayne County. I don't know of any diversion program that we have that would divert them out of the system pre-charging. I think that there are some. I know that Wayne County prosecutor has a diversion, we're working on a diversion program. And we're talking about diverting mentally ill people before they're charged out of the criminal justice system. So these are all things that are being discussed, but I don't know that they're actively, the police have the ultimate discretion to charge or not to charge. And then them, together with the prosecutor, on other cases, they decide. So as far as the decision to charge or not, it's out of the court's hands, but it is in the hands of the officer and the prosecutor.
Thank you.
And to some degree, to speak on that, from a charging perspective, it's harder for the prosecutor's office, and I think the police feel a little bit more with their hands tied. I'm looking at a case and determining whether or not the criminal elements are met. So when I decide whether or not someone's charged, I don't get the ability to delve into, is it appropriate from a personal or subjective standpoint to charge this person? I'm instead looking at the report and determining, I know the elements of this crime, have the elements of the crime been met? I don't necessarily get to engage in the analysis of, does this criminal defendant really need this, or is there some other thing that could be done? Most of the ability to help comes after the charge from our perspective. And I think the police, Deputy Chief Miller could comment as well on that.
Yeah, and if I could add, we may seem like an odd advocate in certain circumstances, but we can be, especially when you get into some of the cases that are a little bit more to them, the felonies that are going to go downtown. The officer in charge of that case, he may want to talk to the parents for no other reason that, hey, at one point in time, this kid might skip town with charges on him. The parents might want him in jail in order to get him somewhere safe, and the detective might want to get them in custody, obviously, because he's got charges. So the investigators can be an advocate in this situation. The detectives, a lot of times, will be in contact with the prosecutors throughout the process. A lot of times it's a back and forth. The prosecutors say, hey, we need this or we need that. They'll discuss, hey, this is a weak case, or, and so there is some input from our standpoint when it does come to that. So it may seem like an unlikely advocate, but the police can be an advocate for the arrestee at times.
Okay, thank you. Any other questions?
My question was for Deputy Chief Miller. He made a great comment. I'm wondering what the statistics are right now with the arrests on people for the homicides of the people that are OD. You made my mind start spinning, seeing that I'm working on the streets of Detroit with the prison project myself, and I'm actually dealing with the guys that could have a record of people who died because of what they put on the streets.
Yeah, I don't have exact stats on that, but I know we've probably had, since we really started hitting it hard, probably 5, 6, 7 cases where we've been able to charge somebody. And the problem with those, and again, it gets to resources, a lot of times if you have a fatal overdose, there might not be any witnesses. We might have nothing more than a phone number. This group here, I think, kind of gets what an addict, how hard it can be to track them down, to track down who they were with last, to track down, numerous things with them. So from a law enforcement standpoint, we work on a lot of times they lead to dead ends. But for actual stats, I don't have exact
What about
stats.
doctors? Are you finding that with the doctors?
Most of the stuff that we've ran into
There's the fentanyl.
has been stuff they've been getting on the streets with fentanyl.
And what about utilizing family and other people to be able to find,
you know, because some of it, I mean, to tell you the truth, is the more that you ask in the community, and I'm sure some of the peers and some of the other people that work in the community, we hear who has it. You know, we hear, you know, where it's coming from. And it's amazing, because I've actually had where it was a family member that gave it to another family member who was a brother that went and died that night, and can still go on as a drug addict and not say anything. That's how terrible this is out there.
Okay. Well, just real quick, and I know we're short on time, but one of the ones we were following up on took us to Detroit to this house, and as we were following up and asking about the body, they started talking about a totally different one. They said, oh yeah, we dumped them in the field over here a couple days ago. And we're like, well, that's not ours, but that just goes to the scope of just how big this problem is.
Well, I just wonder too, if we could use them as this, you know, like the penalty, if it makes any sense, and I think it goes all along too, is that if it was the top person that you were, you know, sending away to prison, the person who was actually selling the stuff, because all they're doing is making money.
And that's the ultimate goal when we do these, because, yeah, 9 times out of 10, they got it from a friend, or they might have been right there, but it's always to get that next tier.
From a prosecutorial standpoint, and this is just how I think, the problem becomes, and I imagine the police run into this, is anytime you charge a crime like that, you're having to tie, it's a thing called proximate cause. So like, you have to show that the overdose that killed this individual came from this person. So the further you go up the chain, the greater likelihood you have of, well, on this occasion, was that what they got from this dude on this block, or this guy 4 blocks over? So you have to be able to connect directly back to that person. So the causal connection between the death and an individual becomes harder to prove beyond a reasonable doubt the further you go up the supply chain. So that's a problem too. Plus, there's this idea that I'm not gonna be a snitch, right? I'm not snitching on somebody. So, to the extent that the people that are around are usually other addicts or other dealers. So, in the world that they're operating in, do they wanna tell on their dealer, or do they wanna tell on, you know, someone they're getting their supply from? It's tough, you know, it's a tough thing. One thing I didn't think that was discussed, but I think is important real quick, is everybody needs to be aware that if there's someone overdosing, there is a statute, and you probably covered it. Yeah, they shouldn't be afraid to call, because they cannot be charged with the offense. And I think a lot of people who are in the using don't know and are afraid to call because they think that they can get in trouble. I don't know. Unfortunately, we know about it, but a lot of people don't know that you're not gonna be punished for calling for help because of this statute. And I think it's important to get that out.
And if you stay with the person, you're not gonna be charged for having drugs or for being high or paraphernalia or anything like that. So it's a good Samaritan statute.
We just had a guy though that called in a dead body, and because he had warrants, spent the next five months in jail.
On something, yeah.
Right.
But he's cleaning up his warrants, so.
All right,
we've
run up against our time, and I just want to, let's give a round of applause for our wonderful panel. And thank you all for coming, and I hope to see you next month.